Hello, my name is Alex Proctor, and I'm the Chief Trust and Privacy Officer at Captain Compliance. In this video, we'll be exploring the evolving world of consumer health data, including the new U.S. privacy regulations that are stepping in to protect it. As we all know, technology is evolving quickly. Sensitive health-related information is being widely collected outside of traditional healthcare settings. Just think about your fitness watch. It tracks everything from your heart rate to your sleep patterns. That data is deeply personal, and it can reveal much more about you than you might expect. As a consumer, you should want to know that that data is being protected. Here's the challenge. Most consumer health data falls outside the scope of HIPAA, the well-known U.S. law that protects medical records. If you go to the doctor, your health data that's collected there is covered by HIPAA, but if your fitness tracker collects the exact same data, it's generally not. That gap has caught the attention of regulators. The FTC has ramped up enforcement against companies mishandling health data, and state lawmakers are stepping in with new laws. Washington, Nevada, and Connecticut have already passed legislation, and New York is considering a bill that could impose even stricter requirements. In this video, we'll break down how these emerging laws supplement existing healthcare and privacy regulations. We'll also discuss how they differ from each other. Perhaps most importantly, we'll explore what businesses need to do to stay compliant with regard to each individual law. What exactly is consumer health data? This term is being interpreted broadly, and for good reason. Generally speaking, it refers to any information relating to a person's physical or mental health, biometric data, or wellness activities, especially when collected outside of a traditional healthcare setting. There are countless examples. Any wearable or smart medical device can generate large amounts of consumer health data. Health and wellness apps can too, particularly those relating to fitness, diet, mental health, fertility tracking, or period tracking. Then there's genetic testing services, online browsing and purchase history related to health concerns, and even social media discussions about medical conditions. The scope of consumer health data is simply enormous. Unlike HIPAA-regulated health data, which is typically handled by healthcare providers, insurance companies, and certain business associates, consumer health data is being collected and processed by a much wider range of businesses, including tech companies, app developers, and even retailers. That's exactly why new laws are being introduced, to fill the gaps where existing regulation falls short. Now, before we explore the emerging state laws, I want to take a moment to clarify the scope of HIPAA. We'll also review the important role that the Federal Trade Commission plays when it comes to consumer health data. HIPAA, or the Health Insurance Portability and Accountability Act, is a federal law that protects individuals' medical records and sets standards for privacy, security, and breach notification. It applies to healthcare providers, health plans, including insurance companies, and healthcare clearinghouses. HIPAA also applies to business associates that handle medical data. HIPAA is very strict, and the Department of Health and Human Services Office for Civil Rights and state attorney generals can issue major fines and penalties. With that said, here's the key point that we need to understand for context. HIPAA does not cover consumer health data because consumer health data is almost by definition controlled by entities that don't fall under HIPAA's scope. That's exactly why the Federal Trade Commission has stepped in. Unlike HIPAA, the FTC has broad authority over consumer protection, and it has clearly made consumer health data an enforcement priority. The FTC Act prohibits unfair or deceptive trade practices, which means companies must process personal data fairly and also be transparent about how they collect, use, and share it. If a company causes privacy harms, or misleads consumers about its privacy practices, the FTC can and has taken action. We've already seen major FTC enforcement actions in this consumer healthcare space. For example, BetterHelp was fined millions of dollars for sharing mental health data with advertisers. GoodRx was penalized for similar reasons, sharing prescription details, health conditions, and personal information with advertisers. And Premom, a fertility tracking app, was flagged for mishandling sensitive health information and deceiving users about its data sharing practices. These cases make it clear, even without a specific federal law governing consumer health data, the FTC is using its existing broad authority to crack down on companies that fail to protect this category of information. Beyond the FTC Act, there's also an FTC health breach notification rule. This rule requires non-HIPAA regulated companies that hold electronic health information to notify consumers, the FTC, and sometimes the media if a breach occurs. While this rule provides important safeguards, it has its limitations. It only applies after a breach has occurred, and it doesn't regulate how companies collect, store, or share health data. In other words, a company can still legally share or sell sensitive health information under its terms of service without necessarily requiring the same types of consent and valid authorizations that these emerging state laws require. Now that we've reviewed the roles of HIPAA, the FTC Act, and the FTC Health Breach Notification Rule, let's switch gears and look at what's happening at the state level. In April of 2023, Washington passed the My Health, My Data Act, a first-of-its-kind consumer health privacy law designed to close the very regulatory gaps that we've been exploring. In contrast with HIPAA and its limited scope, this law regulates any business that collects, processes, shares, or sells consumer health data while conducting business in Washington or targeting Washington consumers. It's notable that simply storing data in Washington does not trigger compliance requirements, an important distinction given the state's role as a major data center hub. The law is applicable to both data controllers and processors. The My Health, My Data Act takes an expansive view of consumer health data. It defines this category as personal information that is linked or reasonably linkable to a consumer and that identifies the consumer's past, present, or future physical or mental health status. The law then lists many specific types of consumer health data, including interesting categories like precise location information that could reasonably indicate a consumer's attempt to acquire or receive health services or supplies. One of the most notable aspects is this law's inclusion of inferred data. This means that even if information isn't explicitly health-related, it can still qualify as consumer health data. Washington's Attorney General gives an example. If a retailer assigns shoppers a pregnancy prediction score based on their purchase history, that score would be considered consumer health data, even though it was derived from non-health-related transactions. This expands the law's reach beyond more traditional health data, making even indirect indicators of health status subject to regulation. Compliance requirements under this law are strict. Washington residents now have significant rights over their health data, including the right to access it, request its deletion, and withdraw consent for its use. Businesses must establish clear processes for managing consumer rights in order to honor these requests in a timely and compliant manner. In addition to respecting data subject rights, the law imposes a range of additional obligations on businesses. Any company regulated by this law must publish a dedicated consumer health privacy policy, clearly explaining how the business collects, uses, and shares consumer health data. Before collecting this type of information, the business must obtain affirmative opt-in consent from the consumer. If they want to share the data, they need to obtain a separate consent. And if they plan to sell the data, they must go even further, securing signed authorization from the consumer before any sale takes place. Beyond consent and transparency, the law includes additional protections. It specifically prohibits the use of geofencing around healthcare facilities to track or target individuals with advertising based on their location. It also holds businesses responsible for ensuring that third-party vendors handling consumer health data follow the same privacy protections, preventing unauthorized access or misuse. One of the most important aspects of Washington's law is its private right to action. Unlike many other privacy laws, which rely on enforcement by the state attorney general, this law allows individual consumers to bring private lawsuits against companies if they believe that their rights are being violated. That's a big deal because it significantly increases the legal exposure for non-compliant businesses, opening the door to lawsuits and class actions. Speaking of enforcement, as I record this video in February of 2025, nearly 2 years after the law was passed, we've just seen a few days ago the first lawsuit filed by a Washington resident alleging violations against Amazon. This case could set an important precedent for how the law is enforced, and businesses should be paying close attention. Washington's My Health, My Data Act is setting a new standard for health privacy regulation. It's already influencing how other states approach consumer health data regulation, and businesses that handle health-related information need to take compliance seriously, not just to avoid regulatory fines, but to mitigate litigation risk as well. What makes this particularly interesting is that while Washington has passed the most aggressive health privacy law in the country, it's yet to enact a general consumer privacy law like many other states have already done. Next, let's take a look at Nevada's consumer health data law and how it compares to Washington's approach. When people think about privacy laws, Nevada may not be the first state that comes to mind, but maybe it should be. While California has received most of the attention, Nevada was actually one of the first states to introduce modern privacy protections, granting consumer opt-out rights for online data collection back in 2019. More recently, in June of 2023, Nevada passed Senate Bill 370, a consumer health data privacy law aimed at regulating health-related data collected outside of HIPAA's scope. In many ways, it shares similarities with Washington's My Health, My Data Act, although Nevada takes a more business-friendly approach. At a high level, SB 370 applies to any business that operates in Nevada or targets Nevada consumers and determines the purpose and means of processing consumer health data. That last part is important. It means the law primarily applies to data controllers rather than processors, unlike Washington's broader scope, which covers both. Nevada defines consumer health data as personally identifiable information that is linked or reasonably capable of being linked to a consumer and that a regulated entity uses to identify the past, present, or future health status of the consumer. While that definition is similar to Washington's, there's an important distinction. Nevada's law determines whether data qualifies as consumer health data based on how it's actually used by the business. In contrast, Washington's law casts a much wider net by using a more hypothetical definition of consumer health data. This distinction narrows the law's scope and may simplify compliance for businesses. Additionally, SB 370 explicitly exempts certain categories of data, such as information used to facilitate video gaming and general shopping habits, categories that Washington's law does not carve out. When it comes to compliance requirements, Nevada follows a similar structure to Washington. The law grants consumer rights, including a right to know, right to access a list of third parties with whom data has been shared or sold, right to request deletion, right to withdraw consent, and right to appeal. Businesses must publish a consumer health data privacy policy that clearly explains how health data is collected, used, and shared. They must also obtain consumer consent before collecting or sharing health data. Though unlike Washington's law, Nevada does not explicitly define what form this consent must take, leaving room for interpretation. Like Washington, businesses must obtain specific written authorization prior to selling data. To ensure the security of consumer health data, businesses are also required to implement measures that protect against unauthorized access or misuse. One of the big differences between Nevada and Washington's approaches is how violations are enforced. Unlike Washington, which allows private lawsuits from consumers, Nevada does not include a private right of action. Instead, enforcement is solely in the hands of the state's attorney general, significantly reducing the risk of consumer-led litigation. This means that while businesses operating in Washington face the possibility of lawsuits and class actions, those in Nevada are only subject to regulatory enforcement. Overall, Nevada's law strikes a balance, introducing meaningful privacy protections without the sweeping complexity of Washington's law. For businesses, compliance may be more manageable, but enforcement risks still remain. Given the increasing focus on health data privacy, Nevada may continue refining its approach, and businesses operating in the state should stay proactive in their compliance efforts. Now, let's shift our focus to Connecticut, another state that's taken action to specifically regulate consumer health data. In June of 2023, Connecticut passed Senate Bill 3, an amendment to the Connecticut Data Privacy Act that introduced specific protections for consumer health data. This approach is unique because, unlike Washington and Nevada, both of which enacted standalone consumer health data laws. Connecticut introduced health data protections into its broader comprehensive privacy law. That makes it the first state to regulate consumer health data as part of a comprehensive consumer privacy law rather than through a separate statute. Under this amendment, any business classified as a consumer health data controller is subject to the law, provided that they operate in Connecticut or offer products and services to Connecticut residents. Unlike other types of data controllers under the law, there are no revenue or processing volume thresholds for businesses handling consumer health data. While the broader law applies to businesses processing the personal data of 100,000 residents annually, this threshold does not apply to consumer health data controllers. Connecticut defines consumer health data as any personal data that a controller uses to identify a consumer's physical or mental health condition or diagnosis, and includes but is not limited to gender-affirming health data and reproductive or sexual health data. This definition mirrors Nevada's approach, which focuses on how health data is used, rather than broadly categorizing all potentially relevant data as health-related, as Washington does. To strengthen consumer protections, the amendment imposes several new obligations on businesses handling consumer health data. Access to such data is strictly limited to employees or contractors who require it for their job responsibilities, and they must maintain confidentiality. If a company shares consumer health data with a third-party processor, a written contract must be in place to ensure compliance with this law's requirements. The law also bans geofencing around mental health, reproductive health, and sexual health facilities, preventing businesses from using location tracking to collect consumer health data. Additionally, businesses cannot sell or share consumer health data unless they first obtain clear, affirmative consent from the consumer. One of the most significant aspects of this amendment is that it classifies consumer health data as sensitive data under the CDTPA. This classification brings additional compliance obligations, including a requirement to conduct data protection impact assessments, or DPIAs, when processing consumer health data. This means that organizations must proactively assess risks and implement safeguards to protect the information. With Connecticut adding consumer health data protections to its broader privacy law, the regulatory landscape continues to push forward. Meanwhile, states like New York are considering even more aggressive measures that could create new compliance challenges for businesses. New York is taking a bold approach to consumer health data regulation with its proposed Health Information Privacy Act, or HIPAA. If passed, this law would impose some of the strictest consumer health data protections in the country. One of the most notable aspects of HIPAA is its broad scope. The bill applies not only to businesses controlling the health data of New York residents, but also to entities processing the health data of non-residents while they are physically present in New York. Additionally, companies based in New York that control the processing of regulated health information are also subject to the law. In contrast with the state laws reviewed so far, this is the broadest in scope. HIPAA defines regulated health information as any information that is reasonably linkable to an individual or a device and is collected or processed in connection with the physical or mental health of an individual. This definition includes location data, payment information, and inferred health data, as long as they can be connected to a person's health status. Compared to existing laws, this definition should be considered expansive. While HIPAA shares some similarities with Washington, Nevada, and Connecticut's health data regulations, it goes further in several key areas. Like other state laws, it requires businesses to maintain a health privacy notice, grants consumers rights of access and rights to delete their health data, and mandates reasonable security safeguards. It also requires businesses to establish contractual agreements with third-party service providers to ensure compliance. What makes HIPAA particularly unique is its aggressive stance on valid authorization. In Washington and Nevada, businesses need affirmative consent to collect and share health data, and they must obtain written authorization for the sale of consumer health data. HIPAA takes this a step further, requiring written authorization for any processing of regulated health information that's not strictly necessary. This means businesses would need to obtain valid authorization much more broadly, including in connection with marketing and advertising activities. The authorization process under HIPAA is extremely stringent. Businesses must provide detailed disclosures and allow consumers to individually approve or deny each processing activity before obtaining a signature. Authorizations must expire after a set period, requiring consumers to reauthorize processing if it's to continue. Additionally, consumers must have the ability to revoke their authorization at any time, reinforcing their control over their own personal health data. Another major distinction in HIPAA is its data disposal requirement. Once regulated health information is no longer needed for its specific and authorized purpose, businesses must delete the data within 60 days or less. This is a notable departure from other state laws, which focus primarily on data collection, processing, and sharing, but do not impose such strict timelines for data deletion. If passed, HIPAA will be enforced by the New York Attorney General, with penalties for noncompliance. Given the state's reputation for aggressive regulatory enforcement in areas like financial privacy and cybersecurity, businesses should expect strict scrutiny if this law is enacted. However, unlike Washington's law, HIPAA does not include a private right of action, meaning consumers cannot bring individual lawsuits, an aspect that makes it somewhat more business-friendly than Washington's approach. As of February 2025, the New York legislature has passed HIPAA, and the bill is now awaiting the governor's signature. If signed into law, it could set a new national precedent for consumer health data protection, potentially influencing other states and even federal lawmakers. At this point, we've conducted a broad review of the evolving consumer health data regulatory landscape. We've examined federal protections like HIPAA, the FTC Act, and the FTC Health Breach Notification Rule, along with state-level regulations in Washington, Nevada, Connecticut, and New York. Each of these laws and the bill are reshaping how businesses handle health-related data, creating new compliance challenges and enforcement risks. If your organization needs help aligning with these regulations, Captain Compliance is here to help. Our privacy platform is designed to streamline compliance, automate key requirements, and help businesses stay ahead of evolving regulations like all of the consumer health data laws that we've reviewed in this video. If you need more information, please feel free to visit our website. It's www.captaincompliance.com. I'll put the link as well as additional contact information in the video description. Thanks for watching.